This is a letter that my mom wrote discussing how she is not in contempt of court for refusal of visitation. I'd like to note before I start this that my mom was only accused of refusing visitation on 10 days out of 8.5 years that we are in the court system in America. Of those 10 days, she could easily prove that she was not in contempt of court for 7 of them. The other 3, I can say that Bill walked away from each visit voluntarily and had no wish or desire to visit with me. This is my mom's letter. I am writing this letter basically with my child's needs in mind. It is important to know that I have been gone for 10 years and have not been found. I have no reason to expose myself except in the interests of my child. I have nothing to come back to. Both of my parents have died since I have been gone, and their house and their farm have been sold. My biomedical engineering degree is useless in getting a job in my field after 10 years without further education or training, and my contacts with family, friends, and former life have all been severed without catastrophic repercussions. Thus, the main reason I am writing to ask for clemency is so that I can come and freely help my handicapped daughter adjust to her first year at a university in a different setting. To understand why I would ask for clemency, I will reiterate my history. I filed for divorce in December 1987. The same year my daughter, Bethany, was born. I gave my ex-husband, her father, Bill Bailey, liberal visitation. Just call before he came. Yet he would come after Bethany was asleep, 9, 10, 11 p.m., and not call before coming. Since I was living with my parents and visitation with me was infringing on my parents' hospitality and time, I asked him to call and let me know when he was coming, or he couldn't come. His response was to take me to court. On 5/13/88, it was ruled that he wouldn't have visitation on Monday, Wednesdays, that he would have visitation on Monday, Wednesdays, and Fridays from 9 to 5 p.m. and on Saturday from 9 to 12. Bill came to me saying he was looking for a job and needed more visitation. I gave him extra time in May and June and told him it would continue until July and he should come and talk to me. I gave him my time with her on Monday, Wednesday, and Friday, as well as his extra time. Hang on. I gave him my time with her on Monday, Wednesday, Friday, as well as his, thus 9 to 8 p.m. I also gave him an extra hour on Saturday from 9 to 1 p.m. I eliminated the extra time above and beyond the court order in July when he failed to check in with me. He complained that I had refused visitation even though I was working during his visitation time and had given him extra time. This seemed to work with the referee since she seemed upset with me. Since I was not permitted to testify on this day, as on many others to come, the referee had no idea what I said happened, just Bill's version. Thus, on 8/17/88, the visitation schedule was changed to Tuesday and Thursday. At least that's what I see. From 5 to 7 p.m. and Saturday from 9 to 1 p.m. or 1 to 5 p.m. This was to come before the judge in 3 weeks to be finalized. In September 1988, due to various complications, while in Bill's care, Bethany had her only vaginal infection to date, an ear infection, burns on the front of her arms, and burns running down the back of both of her arms. Bill agreed to supervise visitation with his parents, my parents, or me. He never had his parents supervised from this date forward, and he said he didn't want to go out off my parents' farm with me or my parents. So I asked a friend if she was willing to go out with him and Bethany. She agreed. The visitation schedule continued as 3 times per week, with Bill coming predominantly every other week on Saturdays and calling during other visitation times to make sure I was where I was supposed to be. He also continued to bring me to court every spring and every autumn. This continued through July 1991 when he started to come every Saturday. Then in September 1992, after Bill said he wanted professional supervisors, he started coming every Tuesday and Thursday and Saturday as per court order, since I was paying for the visitation supervisors now. He refused to pay half of the costs. The next order, after objections were filed, was ultimately January 7th, 1993, which stated that Bill had either Saturday or Sunday from 9 to 5 p.m., with the exception of some times in January and February 1993. This was the order until the beginning of May 1995. The main motions that became pivotal in the case were Bill's motion of March 20th, 1992, asking for unsupervised visitation, Bill's motion of September 11th, 1992, for contempt of court for refusal of visitation, and Bill's emergency motion of December 10th, 1992, in which I objected to his wife, then fiancée, being the supervisor. I was found in contempt of court for refusal of visitation for 10 of these 862 scheduled visits. Yet I'm refusing him visitation? Of these 10 dates, I can easily document on paper that I'm not in contempt of court for 7 of these days. As for the other 3, those will be explained after. The first 7 are 10/11/92, 10/29/92, 12/22/92, 1/31/93, 2/6/93, 6/13/93, and 8/17/93. 10/11/92. In the referee's report of 11/8/94, she states, on October 11th, 1992, Father wanted to take Bethany out to the zoo with Miss Taylor Bailey. Mother refused unless she was permitted to go along, and the parties debated the court order in front of Bethany. Mother offered to let Father visit in the home. Father refused and started to leave. Bethany cried because she had wanted to go with Father. Father said to Bethany, "It's your mother's fault." I don't understand why I am in contempt of court on this date. At this time, the visitation agreement was that of the final divorce decree, where William B. Bailey will continue supervised visitation at the home of the parents of the plaintiff or defendant. At this time, supervision was to be by Miss Farmer and her parents or Mr. Bailey's parents. Thus, as far as I can tell, I was not in contempt of court. I can only assume that the referee thought that this incident occurred after her report on October 23rd, 1992, that Father be allowed to choose the visitation supervisor from a specified list which included his then fiancée, Lynn Taylor. Even if this referee's report, 10/23/92, could somehow apply retroactively to an incident 12 days earlier, my lawyer filed an objection. A point of law is that once an objection is filed, the order does not go into effect until it is heard by the judge. The hearing on this objection was not heard until 1/7/93. Thus, the referee's ruling, which I supposedly violated on 10/11/92, was not legally in effect until 88 days after the visitation occurred. In addition, my witnesses for that day was quoted incorrectly in regards to the facts of the visitation. After learning about the ruling, he wanted to right the wrong. He wrote a letter to the court to air his concerns about the ruling. Mr. Grill states, "Because I was shown a copy of the referee's decision in this document, there is an instance where my testimony has been changed from what I originally reported. The referee reports that on October 11th, 1992, during a scheduled visit between William Bennett Bailey and Bethany Farmer, the daughter of the plaintiff, Bethany, cried because she had wanted to go with her father. This is a mistake. My testimony given that day, as confirmed by both Miss Farmer and her lawyer, is that Bethany Farmer was indeed crying, but not because she wanted to go with her father, but rather because she was very upset with her father. Bethany verbally asked her father why he was trying to hurt both herself and her mother. This is what had her in tears. I do not know how my testimony could have been misinterpreted, but I believe that the mistake was critical in understanding what actually occurred on October 11th, 1992. I feel that due to the importance of the referee's decision, the mistake in the report of my testimony needs to be clarified." 10/29/92. There is no statement within the report of the referee King, 11/8/94, supporting the contempt charge for this date. There is nothing in her timeline either. A letter from the supervisor, Terry Kessinger stated that my 1992 date book indicates that I did supervise visits from mid-October 1992 through early 1993. October 29th and December 22nd, 1992 are included among these dates. However, I have no particular recollection of either of these visits. Thus, I can document the visitation occurred on this date. 12/22/92. The referee did make mention in her timeline that 12/22/92. While there was visitation for much of December, on December 22nd, Bethany spit, hit, and bit at her father. She did not go on visitation. Once again, I have a document from the supervisor, Terry Kessinger, that states, my 1992 date book indicates that I did supervise visits from mid-October 1992 through early 1993. October 29th and December 22nd, 1992 are included among these dates. However, I have no particular recollection of either of these visits. Thus, I can document that visitation occurred on this date. 1/31/93 and 2/6/93. The referee does not refer to either of these dates in her report, but she does refer to these dates in her timeline. For 1/31/93, she states, Father and Miss Taylor were present for the visitation. Visitation was refused because of a letter from attorney Sherry Slavin, which indicated there would be no visitation. For 2/6/93, she states, Father and Miss Taylor were present for visitation, but visitation was denied. Also, Mother and Bethany were not present for visitation and no visitation occurred. These incidents revolve around the fact that there was a hearing on 1/27/93, which I was told not to attend, that changed the dates of visitation. Before 1/27/93, visitation occurred on alternating Saturdays and Sundays. At the hearing of 1/27/93, the visitation was changed to Thursday, January 28th, Thursday, February 4th, 1993. I learned of this on 1/27/93 through a phone call from my attorney. The telephone conversation was followed up by sending a fax on 1/28/93. She stated that the only times of visitation were to be Thursday, January 28th, and Thursday, February 11th, 1993. She made a mistake in the fax in that the second date should have been February 4th, in that it was before the hearing date. Here is the fax. Via fax. Peggy Farmer has arranged for Terry Kessinger to be present from 5:30 to 7:30 to supervise the visitation of Bethany on Thursday, January 28th, today, and on Thursday, February 11th, 1993. This will be the only visitation time until the hearing on February 9th to determine the issues. So that was via fax. She also indicates that this will be the only visitation time until the hearing on February 9th to determine the issues. After the telephone call and the fax, Mr. Bailey showed up on Thursday, 1/28/93, and visitation occurred as ordered by the court. However, when Mr. Bailey showed up on Sunday, 1/31/93, and Saturday, 2/6/93, I was not present with Bethany because I did not think there would be visitation. Thus, as far as I can tell, I was not in contempt of court. In regards to these 2 days, Mr. Bailey has never stated in court that my facts were incorrect. He came on the 2 Thursdays, which would normally not have been visitation days according to the court's order, so I assume my information was correct. Thus, I repeat, as far as I can tell, I was not in contempt of court. 6/13/93. The only statement of the referee concerning this date is in her timeline, which states, there was no visitation because wife alleged that Bethany was ill. She had no temperature and seemed to be all right. The major problem with this incident is that Sunday, 6/13/93, was not an approved day of visitation. I have a photocopy of a cash check that was written on Saturday, 6/12/93, the day before, to the supervisor, Taylene Cassidy. Thus again, I do not see how I was in contempt of court. Here is the photocopy of the canceled check. Okay, 8/17/93. Again, there is only the timeline of the referee to indicate why I was in contempt of court. She states, Father was present with Lynn Taylor and attempted to visit with Bethany. Again, Mother refused to let them take Bethany because of her alleged belief that Miss Taylor was not a valid supervisor. I did not refuse because I thought Miss Taylor was invalid. I did not come for visitation on 8/17/93 because it was not a visitation day. A look at the calendar shows that 8/17/93 was a Tuesday, and all visitations were either on Saturdays or Sundays. I have a copy of the cash check that documents payment to the supervisor, Kim Simmons, on the correct visitation date, Sunday, 8/15/93. Here's the canceled check. $1/9/93, $1/17/93, and $1/23/93. These 3 days were addressed in the timeline of the referee, and she stated a different reason for each visitation day. Yet all 3 of these days were similar in how they developed. My daughter Bethany, having Asperger syndrome, falls into the statistics for children in that she detests when someone lies to her. In January of 1992, Bethany yelled at me and my parents, maternal grandparents, for lying. She told us that she would prove to us that Bill was telling the truth and that we were lying. What she proved was the opposite. After this time, Bethany did not want to go out with Bill. No one knows of this in the court because I was not permitted to testify to this. Thus, when Bill came with Lynn as the supervisor, Bethany asked for me to go with her. I told her I could not, so she asked her grandmother. Since there was no court order refusing, the grandmother, my mom, said yes and got her coat. Bill said that I was refusing visitation and left. For the next 2 weeks, Bethany asked for adult friends, once again to go with her father on visits. This time she chose in advance and each time chose a man to go with her, but Bill refused and left. Bethany then said that if he is allowed to have a friend, then she is allowed to have a friend. Thus, I could have thrown her in the car, but I didn't feel that was appropriate. As she said, it's my visitation too. Thus, I don't see how I am in contempt of court for Bethany refusing to go and Bill deciding to leave rather than visit. From this point, the case was transferred to juvenile court, where proceedings seemed to be against me. They seemed intent on taking Bethany away and sending her to a mental hospital. This is why I left. I am really not sure why this was done, because I never was served with papers and was never told anything was wrong. I was in the courtroom for all of 5 minutes before the referee and told to sign a paper saying that I was an ineffective parent, or they would take Bethany away. Given that choice, I did as I was told and signed the paper. When the social worker who worked with Bethany was fired from the case, I decided for Bethany's welfare it was time to go. Thus, that is why I seek clemency. I appreciate your time in reviewing this matter. Thank you in advance, Peggy Farmer. And more. I will keep going. More discussion about how she did not refuse visits. Just for anyone who didn't understand that, maybe this will make it clearer. Date of contempt for court violation for refusing court-ordered visitation, 10/11/92. In the referee's report of 11/8/94, she states, on October 11th, 1992, Father wanted to take Bethany to the zoo with Miss Taylor Bailey. Mother refused unless she was permitted to go along, and the parties debated the court order in front of Bethany. Mother offered to let Father visit in the home. Father refused and started to leave. Bethany cried because she wanted to go with Father. Father said to Bethany, "It's your mother's fault." I do not understand why I'm in contempt of court on this date, 10/11/92. At this time, the visitation agreement was that of the final divorce decree where William B. Bailey will continue supervised visitation at the home of the parents of the plaintiff or defendant. At this time, supervision was to be Miss Farmer, her parents, or Mr. Bailey's parents. Thus, as far as I can tell, I was not in contempt of court. I can only assume, based on the timeline given by the referee, 11/8/94, that the referee thought that this incident, 10/11/92, occurred after her report on 10/23/92. That father be allowed to choose the visitation supervisor from a specified list, which included his then fiancée, Lynn Taylor. Even if this referee's report, 10/23/92, could somehow apply retroactively to an incident 12 days earlier, my lawyer filed an objection. Blah, 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 blah. I think this is about the same letter, so I'm going to actually quit. Oh yes, this is the part I want to read. I'm sorry. I won't go over that again. I have all the violation of visitation, contempt of court stuff. This is what I wanted to read. Excuse me. Disregard that, anyone who heard that. Because of the large number of cases before the court, referees hear the testimony and recommend rulings to the judge. Of the last 13 times I've been to court, only 2 times, half hour each, have been heard in the presence of a judge. 11 times, about 11 full days, have been heard by a referee. I am coming to the media because the judge has deferred to the referee to decide the case rather than hear it herself. I am concerned that the referee is not making a good, fair judgment. In fact, in the opinion of every attorney that I have engaged in this matter, the referee, Kathy King, has been hostile to my position. She has continually ruled against me and for Mr. Bailey. For example, Mr. Bailey has contended several times that I am engaged in a campaign to fabricate sex abuse or to alienate him from Bethany. 3 psychologists have testified that I was not so engaged. One psychologist, Dr. Ramonic, testified that one of the factors that convinced him about me was that I was willing to take a polygraph test with regards to my claim. As outlined in referee's report, see document C enclosed, Referee King goes on to say, on 11/8/94, that although Mother did apparently verbally agree to Dr. Ramonic's suggestion of a polygraph test, Mother did not follow through on the original agreement verbally made between the parties in court on the polygraph test. Enclosed is a letter giving the results of the polygraph test that I took on October 5th, 1992, 2 years before Referee King's accusation that I would not take a polygraph test. There are more examples which I can produce, including legal aspects which were mishandles, as well as these key and blatantly obvious problems. I am pleading that someone pay attention to this problem. Thank you, Peggy Farmer. What's interesting is when the results of the polygraphs came back, when she found out that my mom's was positive and good, she claimed that it really wasn't and that polygraphs don't work. Now, how she can say she didn't take it and at the same time say that that it's not valid is quite beyond me. So, yeah, that's disconcerting to say the least. Okay.